we're gonna at least real quick kick us off here while a few people are still joining us. So as you can see, a few of us are in the room, and then many of you will be online. My name is Hubert Zaitchik, and I run Health Walkouts, and we have met probably Java or Lindsay along the way to make this selection happen. And our guest today is Chris Simpson, shareholder with Polsinelli. And as you can see, he's already shared his screen, part of the venture capital and emerging growth practice at Polsinelli. Amongst the things he does there is not just in the US, but also cross-border stuff, from what I saw. Anything that you might be stumbling across as you start your business, take on money, get acquired in the early stage of things. He covers a variety of industries, so not just life sciences, but also ag tech and food and beverage and technology in general. And Chris is a speaker in our accelerator program every year. Polsinelli is one of our longest standing sponsors in Health Walkouts as well. So we've been a long-standing relationship with them. And Chris also comes in and advises our startups who may choose to engage with him at Polsinelli. He got a solid 2 Notre Dame here, so the undergrad and law school.
Grad school, law school at Notre Dame, then I did a year at our Notre Dame London program, then I did undergrad in the Northeast at Wesleyan University.
There we go. Oh yeah, got it. Yeah. Now I see. Yeah. So and a variety of other accolades, including One to Watch, Best Lawyers, and all the good stuff that you would expect from a top law firm attracting somebody like Chris. And then prior, you were with Paul and Stewart in Boston as well. So we just know him as Chris because he helps our startups and fixes things early before it's too late. And with that, and then you live in Kansas City, right?
I live in Kansas City. Yep. And so I live in Kansas City. Polsinelli has offices across the country. I come down to Dallas quite frequently in connection with our Health Walkouts relationship, and also to visit with clients. In the summer months, I am spending a lot of time out of our Boston office. I have family in the Northeast, and so we'll operate in that territory.
Awesome. Well, I'll kick it over to you. Thanks for being here with us, and I'll let you run the show.
Lovely. Well, great. Well, thanks everyone for coming today or joining on Zoom. I'm really happy to be here to speak with you all. As Hubert mentioned, I am a partner or shareholder, as we call it, over at Polsinelli, and I sit in our venture capital and emerging growth practice group. My focus is primarily on life science. This is me much younger and prettier. My focus is largely on life sciences. I work with my clients all the way from incorporation through their first, say, pre-seed financing round, through their Series A, Series B, IPO, or sale transaction. In addition, I serve as general outside counsel to all of my clients. And so by general outside counsel, I support them on things like commercial contracting. If you're a life science company and you want to do a complex development or collaboration agreement, I'm your guy. If you have questions about equity compensation, general executive compensation, IP protection, kind of the ins and outs of what you need to do to make sure that your company is properly set up and protected. I kind of serve as the spoke in the hub and wheel. We have a hub and wheel approach, and I am in the middle of it, the hub, not the spokes. So the purpose of today's luncheon is really to talk about the ins and outs of startup entities, and what form of entity should you be choosing? What should you be thinking about when you are starting a startup, essentially? I've also included a couple slides on fundraising, primarily pre-seed efforts at the end. And generally speaking, when I have these types of presentations, I love for them to be as collaborative as possible. So if there is something that you want to ask me, please jump right in. If there's anyone on the Zoom that would like to type in a question, we can make sure that I address it before the end of the call. But generally speaking, I'd like this to kind of be as interactive and as helpful as it possibly can be. So with that, I'm going to dive right in. So running a startup, I'm not sure where everyone at this table, where you're at with respect to your efforts, but having represented over 200 startups, I can tell you that it can be fraught with a lot of pitfalls and potential sharks in the water. And so our operating model is we love to engage with our clients as early as possible to ensure that they are being set up for success, and ensuring that they have the proper documents in place when they get started, so that they are ready to take in capital, ready to engage in those commercial contracts with third parties. And so the key question we always look to address is, what type of entity should a startup use, and where should that entity be formed? In the United States, incorporating or organizing a company is a function of state law. And so every state has its own Secretary of State that allows you to set up a company. Why you need a separate legal entity, this is very high level and probably quite obvious, but you always want to set up a separate legal entity when you are going out and starting up a new business, for a number of reasons. One, you want to protect yourself and your personal assets from liability from your business activities. A corporation or limited liability company can operate as a shield to ensure that your personal effects are properly protected. Two, you want to establish clear ownership rights in a business's assets. So, for example, if you have a great intellectual property idea, we want to make sure that it's properly housed in a entity, largely for purposes of contracting and attracting future capital. Next, we want to make sure that you have properly issued out equity to founders early to avoid a tax nightmare, which we'll get into in a few minutes. And then finally, we want to be able to take in outside capital and have separate, segregated bank accounts to ensure that your investors feel good about giving you money. So there are a handful of entities that you can choose to use when you are building out your startup. The two big ones are C corporations and limited liability companies. I included S corporation because I wanted to touch upon it quickly, but generally speaking, our clients at Polsinelli, we recommend them follow the C corporation model. Now, the C corporation is a double taxation model. You have stockholders and the entity itself. The reason why we like C corporations as opposed to S corporations, which are pass-through entities, is to allow the C corporation to issue out separate classes of stock. We'll get to that in a few minutes, but generally speaking, an S corporation can only issue out one class of security. So it would be just common stock. An S corporation can't issue preferred stock. In addition, an S corporation is treated as a pass-through entity. So any tax that an S corporation has to pay flows up to the owners, very similar to a partnership. A C corporation, there is essentially a block. The C corporation pays taxes on any of the income that the C corporation takes in, and the stockholders of the C corporation only need to pay tax if dividends or distributions are paid up to the stockholders of the C corp. Limited liability company is a relatively new, within the last 20 to 25 years type of entity. It is also essentially set up for tax purposes as a partnership, meaning that the limited liability company is a pass-through entity. There's no line of demarcation or dividing line between the limited liability's tax obligations and its partner's obligations. The LLC's tax is addressed by its partners. Generally speaking, I'm going to stick on the slide one more minute, even though it's pretty short. Generally speaking, again, we like to see C corporations in large part because if you are a startup that is looking to attract venture capital or institutional capital down the road, a lot of those investors will only invest in the C corporation. Now, to be sure, there are investors, especially family offices, angel networks, that are not as opposed to investing in a limited liability liability company. But as a general rule, we just see going down the path of a C corporation to be better long-term for your potential investors. Now, that might be a little bit counterintuitive to what some of the benefits of a limited liability setup could be. When you set up a limited liability company, whether or not you're a partnership or a sole proprietor, you can take losses on the limited liability company's activities. And so if you have invested a lot in your LLC and you want to report losses from the LLC on your personal taxes, you can do that if you are structured as an LLC, which leads a lot of people to originally organize as an LLC at the very, very beginning. I'll stop right there. Are there any questions about, the type of entities and why we like to go with a C corporation versus an LLC? Again, it's largely a function of what investors like to see and tax analysis.
Great overview, and I think I understand. But is a C corp more expensive or more complex to set up, or is there any difference in just legal aspects of setting these three up?
It's a great question. I think that generally speaking, it's about the same. It's a few $1,000s inclusive of filing fees payable to the Secretary of State of the applicable state in which you organize or incorporate.
So all of the Secretary of State.
Yeah, exactly. And look, there are a lot of entities like, I'm sure you've seen ads for LegalZoom and other like Harvard Business. They will provide these types of basic formation or incorporation services. Just generally speaking, when you do set up an entity, whether it's a C corporation or an LLC, you just want to make sure that you've also, if you have, say, co-founders, you want to make sure that you've properly documented and papered the ownership stakes and rights of each co-founder. So there are there's a checklist for each of a C corp and an LLC that you just want to run through when you are setting one up.
What's the current view on state of incorporation? Where's the best place? What's the best state to go to?
It's still Delaware. So Delaware has been and continues to be the default state that people incorporate or organize in. It's the same whether or not you are a corporation or a limited liability company. There are a number of reasons for that. One, it's can be deemed partially path dependency. Delaware has always been the state in which people have organized or incorporated. They've made it kind of very easy or attractive to do so. Two, the courts in Delaware are quite sophisticated, and they will produce a lot of guidance with respect to how the Delaware statutes operate. And so when investors are investing in a Delaware corporation or a Delaware limited liability company, they feel comfortable that they understand fully, what their fiduciary duties are if they're a director of the entity in which they have invested. So there's a little bit more certainty when you are investing, say, in a Delaware corporation, or if you're a founder of a Delaware corporation, you have a better sense of what your expectations and obligations will be under Delaware law. Now, to be sure, there is nothing necessarily or de facto wrong with incorporating in Texas. We do have a number of clients that are Texas corporations or limited liability companies, but generally speaking, Delaware is kind of the de facto state for incorporation or organization. And that's just how we continue to operate. You will see a number of states like Nevada and Wyoming are now trying to be competitive with Delaware to see if they can kind of attract those franchise tax fees and the filing fees. But you can be operating in Texas, you can be a Delaware corporation. So it doesn't matter what state you're operating in, you can always incorporate in a state outside of your place of business.
Yeah, you got a question with that statement?
Yeah.
Yeah,
hey,
Jen.
Yeah. Hey, Chris. To add on to that, I was just kind of curious just to make sure that I'm understanding this is right, because this has happened to me before on a couple of companies with that Delaware filing. If I'm correct as well, depending on if you're not really making any money, right? Being a startup sometimes, right? It's a little different in the beginning. in terms of your taxes, like you will always get a nice large tax bill every year from Delaware, but then once you file your actual, like, we're not making any money sort of content, I believe that the filing or the taxes due are like, what, $300-400 at the minimum, right? If you're not making any revenues as well when you go that Delaware route too.
That's exactly right, Dennis. So the Delaware Secretary of State, they will levy franchise taxes on an annual basis. And what they do typically is when they deliver their tax assessment, they use what we call the authorized share model, which can result in early stage companies, whether or not they've made a single dollar, thinking they may owe anywhere from $10,000 to $200,000 in franchise tax fees, because the Secretary of State of Delaware bases the tax upon the number of authorized shares that you have included in your Delaware certificate of incorporation. And typically, we recommend that you have somewhere between 5 and 10 million authorized shares. But you're absolutely right that the alternative way to calculate your Delaware franchise tax is through the asset value basis. And so if you're a startup, practically speaking, your assets are worth relatively little, right? You might have a nice valuation that you can find on the marketplace, but your hard assets are not worth that much. And in that case, and this is what we do for all of our clients, your franchise tax exposure is only $350. So that's the amount that you would pay per year to the state of Delaware.
Thank you.
Yep. Anything else on corporations versus LLCs, state of incorporation or organization?
Can you tell us a little bit more about the legal protection? Like we're touching on the tax implications of these different structures. What about legally, do they offer similar levels of protection?
Yeah, it's a great question. So legally, they do offer similar levels of protection. A C corporation and a limited liability company, they're both wholly distinct legal entities. And so they do serve as a liability shield for their owners, right? So if the company has some sort of slip and fall litigation dispute brought by a third party, the corporation could be on the hook, but the stockholders would never be on the hook for that. Under Delaware law, C corporation directors have fiduciary duties, meaning that the board of directors of the C corporation is required to act in the best interest of the stockholders, right? Limited liability companies, you should just kind of operate under that same model. There is some kind of wonky, interesting components of the Delaware LLC statute that some say can allow you to essentially waive fiduciary duties for LLCs. We don't advise you do that, but it's so generally speaking, they're very much the same in that they will offer their owners adequate liability shield protection, but it is largely driven by tax. And the reason why investors like to invest in C corporations versus limited liability companies is partially a function of tax as well. If, say, a venture capital fund has foreign LPs, limited partners that have put money in, they want to have what we call a blocker. Essentially, the C corporation is the blocker that prevents their foreign LPs or fund investors from having any sort of US tax exposure. In the case of a limited liability company, because it's taxed as a partnership and it's a pass-through, you kind of have to go up the levels. And so if the partner in a LLC is a venture capital fund and they have foreign LPs, the K1s, which are what the company has to issue to its partners, they have to go up to the fund, and then the fund also has to report on its foreign investors, LPs. And so there's what we call UBT. It's a very kind of wonky tax component.
So there could be tax liability that you then end up on the hook for, because if the foreign partner doesn't pay it, it's phantom tax.
Exactly.
Anyway.
Yeah.
You're gonna not pay it.
Yeah.
You open up a can of worms, and you might end up being on the hook as a venture fund.
Exactly. And it's a can of worms. And let's say you're a venture fund and you've invested in an LLC that has operations or is receiving profits from 20 states or 30 states. You could be required to, the LLC would be required to file a tax return in each one of those states And in addition, the partners have to make filings as well in each one of those states. So it starts to become a just a potential burden or hassle for funds. And again, it's not to say that you can't do it. We have a handful of clients that have raised successful rounds as LLCs. But the farther you go down the road, and for example, the closer you get to say IPO, if you're on that trajectory, the better being a corporation is. You cannot be a publicly traded company as an LLC. You have to be a corporation. So.
Can I ask a question about parent company? So if a foreign entity was to start a US subsidiary, would that just be a C corp? They would have to.
Yeah, typically speaking, and there are certainly considerations to give, but if a foreign founder or foreign investor wanted to start a US based company, our default would be C corporation. It would be, and then that allows that blocker and the tax components like we talked about. And then if you want to set up, we certainly see a number of situations where we have a holding company like that C corp drop down different LLCs as operating companies for a handful of reasons. If you want to kind of silo your business verticals, or for example, if you're a coffee company or a coffee chain and you need to have an LLC for each of your locations to try to limit liability.
So if I have an LLC and I continue to grow, can I move that into a C corporation?
That's a great question. And the answer is absolutely yes. So every state, or I would not say every state, but every state has what we call statutory conversion, meaning that if you are a limited liability company, either taxed as a sole proprietor or as a partnership, you can convert into a C corporation and file the change with the Internal Revenue Service. Yep.
Thank you.
Yeah.
Are you familiar with, I was advised on LLC that in Texas, probably other states too, you can have an LLC Series 1, Series 2 under it, and that protects your liability.
Yep.
You like that model?
Yeah, that's a good model. Sure. And so if it's a really good point, Series LLC is another function of state law, and it's designed to allow you to, partially about, I was talking with Paul about, to silo liabilities for separate verticals. Exactly. That does work. Yep. Yep. And so it's kind of like, it's almost like, just a statutory holdco with, drop down subsidiaries just set up as Series 1, Series 2, Series 3 LLCs.
You have to keep good record keeping, which expenses go with which series, which revenue.
That's exactly right. Because if you don't kind of clearly bifurcate, then the advantage of the Series LLC can fall away because you're commingling or mixing all of your assets.
Just as the checks come in, they say LLC, man, you found a Series 1, that's just what the daily order.
Exactly right. Exactly right. And so we have a couple questions in the chat that I might just jump into right now. So the first question is, what are your thoughts on starting a life sciences healthcare company as a nonprofit? What kind of entity would that be? So the short answer is sure, yes, you can absolutely start a life sciences healthcare company as a nonprofit. But it's going to limit your sources of potential capital down the road. If you are a not-for-profit, then you don't have stockholders or shareholders. Individuals can't invest in you. You can certainly solicit and receive donations if you properly qualify as a not-for-profit under the IRS. And you will likely be able to receive grants from institutions, universities, et cetera. But again, it makes your fundraising potentially a little bit more difficult because you are not able to receive capital investments in the nonprofit. And then a quick question from Andrew Trock. He asked, an LLC is a disregarded entity. Yep, totally agreed. Election to be taxed as an S corp is a separate election from establishment, is done to the IRS. Agreed, Andrew. Yep. And then one additional question he asked about incorporation. Until recently, it had to be in Delaware. Now, post the Chancery Court's interference on Elon Musk's remuneration, the rule is anywhere but Delaware. The decision made by the Court of Chancery on Elon Musk that obviously garnered a lot of media attention, right? There are ongoing and active conversations amongst attorneys, whether or not that actual decision will flow through and impact companies other than Tesla. At this point in time, we are still recommending that Delaware be the default. But I guess it's one of those kind of wait and see situations. I expect to. Fair enough, Andrew.
Yeah, but this is it.
I expect to earn a lot more than Musk.
I agree.
Yeah. So now that, let's just say or assume that you've decided that you want to incorporate your startup as a C corporation, the next handful of questions or considerations are the following on this slide. Key things to think about. Control. Unless you're a sole proprietor, and unless you don't have any partners, you're going to need to figure out how you're going to be, approaching control and decision-making process. If you have two co-founders, are the two of you just going to be 50-50? Does that mean that you all, or the two of you have to agree on every material company decision? Is one founder going to kind of be the tiebreaker? Does that person own, 51% versus 49% of the company? That goes to equity. How will you divide the equity amongst yourselves as founders? Additionally, as you are standing up a company, it's possible, if not probable, that one or both of you will be investing cash or potentially IP. And IP, means ideas or technology, or business plan, operations. How will those contributions be treated? Succession plans. If you are a co-founder and this, startup gig is not working out for you, what happens if you leave? Further, forced departure. Is there a situation where a co-founder can be forced out by his partner? Or are there scenarios in which you could be, you both could stay? We typically like to try to divide forced departures by, for cause reasons versus not for cause reasons. I'm just going to go to the chat real quick.
Define those two terms. I never quite knew what cause and not for cause meant.
Yeah, absolutely. And so let's use the hypothetical that there are two founders, right? And let's say that we have built into your stockholder agreement the concept that one founder can elect to essentially kick out the other founder if the other founder has, it can be terminated for cause. For cause is a defined legal term, and the components of that legal term can be established by the co-founders. But generally speaking, for cause can be anything from moral turpitude. It can be, willful misconduct or fraud on the business. It can be charged with a misdemeanor or felony. And so there are kind of a laundry list of standard for cause provisions, and that we would include in the stockholder agreement. They're intentionally, high thresholds to meet. For cause in the context of two co-founders would not be, a foot fault or, not coming to a board meeting. Something like that would not rise to the level of for cause. It would be serious actions that could be detrimental, materially detrimental to the company.
In the corporate world, it seemed like they could often find a cause, or
Oh yeah, in the context of a corporation they establish, a Fortune 500 company, they can find cause.
yeah.
They'll figure it out. Yeah.
How common is it for, let's say, for cause can be established, that founder has to leave, for that founder to be in a situation that the legal paperwork would mean forfeits all or almost all his equity?
Yeah.
I've seen a situation like that in Germany. That was like, say what? So is that typical? Is this a VC term?
That's a really good question. And so generally speaking, when there's more than one founder, we like to put their stock subject to vesting, because in theory, if you don't put the stock subject to vesting, typically we like to see 2 years, 3 years, 4 years for a founder. So that means that if you have stock issued to you, that stock vests over time and would not be subject to, nominal repurchase by the company if you were to leave. The point of that is to ensure that, if you and your co-founder, and maybe you have a buddy that you want to bring with you on this startup journey, if that buddy gets his stock fully vested when you guys start up the business, but he or she doesn't do anything, and then you guys take off as a company and you're a unicorn and you're valued at $1 billion, but this guy has not contributed a single bit of work to the company. He actually doesn't even work for the company anymore. He could be in line for an unfounded windfall if you don't provide that the stock is subject to vesting. The context that you're talking about is a really interesting and good one. So if a founder is terminated for cause, the stockholder agreements can provide that stockholder would have to forfeit his or her stock for $1. If a founder is terminated for any reason other than for cause, then the redemption price is typically much higher, or the founder is not required to forfeit his or her shares.
You say the cause is typically listed earlier on, and so each company might have a different list of causes, and not a standard list of causes.
That's exactly right. And this is one of those things that we try to hammer home with our early stage clients. When you are setting up your corporation with, your co-founders, you're assuming that everything's going to be copacetic, right? You are not planning for a potential divorce down the road. You are just thinking about growing the business, and you are operating under the assumption that all parties are going to act in good faith. What we do, and why we basically the real value that we bring as attorneys, is to think about the worst case scenarios and the downsides. And so that is when we like to build in for cause provisions very early on with co-founders to make sure that everyone is very clear, what would happen if you were, arrested for a felony.
I heard one attorney say, I'm in the real estate business, not a real estate person, is he's seen more conflicts, not when the business is failing, but when they're making a lot of money, that there's more to slice up. So that's anything you've seen.
Yeah, no, I mean, I think that when the tide rises, you can certainly see partners who were very close start to maybe potentially get a little bit greedy.
Yeah.
And there are special ways that you need to approach that. So it's both downside and upside. When you're making a lot of money, that can be a good thing, right? But there certainly can be situations where founders are just not getting along. Yeah. So I'm just gonna, yes.
Forfeiting your vested portion is a whole nother deal.
Oh yeah.
They're taking potentially everything that you have,
Right.
not just the unvested portion in that scenario. That's a serious deal.
Yeah, and so forfeiture of the fully vested stock, again, that is going to be something there that only happens when that founder has been terminated for cause. It could be even like super cause, like if you want to give up.
No, I get it, but still, it's like you think that's your company you started with.
Totally agree.
So,
and to be sure, these types of issues are issues of contract. And so they can be agreed upon by the co-founders, by the first couple stockholders. And so, if the co-founders decide that there is no scenario in which they want their vested stock to be subject to forfeiture, then the stockholders agreement is not going to include that. So there is some flexibility, and it's just a matter of thinking through and walking through the worst case scenarios.
In the case of divorce, let's say that one of the founders who's leaving is allowed to keep their vested stock. How typically does that pan out? Is that generally, and then they want out, they don't want to just, they don't want equity in the company. Is that one of the other co-founders buying them out, or how typically does that respond?
Yeah, it's a great question. And it partially depends on what stage of the company's life cycle the company is at, right? And so if you're, starting out and you're very early and, you don't have revenues above $100,000 a year, or even if you have revenues of $1 million a year, it's probable that the company's not going to have the cash to necessarily buy out a co-founder. Now, if a co-founder on an individual basis wants to buy out his or her co-founder, that's certainly something that can be discussed. For what it's worth, too, as a company grows and their trajectory goes upward and institutional investors or financial sponsors get interested, there's always an opportunity for an investor to come in, invest in the company, and a portion of those funds be used to buy out a co-founder who would like to no longer be part of the company. And so that's, typically speaking, that's probably the most common approach, unless one or both co-founders has deep pockets and is able to buy out the other on an individual basis.
How attractive, typically if you're having outside investment, they're interested in kind of later rounds, kind of being up the food chain, so to speak, on the cap table. How interested are they typically in what is typically common stock for founders, right? So it seems like I can see a deal like that coming through, but generally, especially new money, they're interested in preferred. It's not common.
That's a great question. And so what you're contemplating or flagging is essentially what we call a secondary transaction that gives founders or early employees the opportunity for some liquidity before the company goes public or before the company is acquired. And in that case, you're absolutely right that any investor is typically investing based upon the expectation that they will receive preferred stock. I will tell you that through some legal juggling and hoop jumping, an investor can purchase common stock from a founder, and the company can then convert that or flip it to preferred stock with no tax or other implications. And so that's how we typically approach a secondary transaction. I just did one 2 weeks ago, so that the investor comes in, say the investor wants to invest $20 million, it will purchase 15 million in new preferred stock, then it will purchase 5 million common stock, and then we will have documents put in place where the 5 million in common stock that they purchase is flipped to the preferred stock. So in sum, they are receiving $20 million of preferred stock.
Does that have an impact on common shares outstanding legally for the structure of the corporation?
It does not. It obviously results in the new investor coming in and owning a little bit more because you've reduced the number of shares of common stock outstanding.
Those are extinguished, right?
Those are extinguished, yeah. But the rest of the founders or employees are able to maintain ownership of their common stock, so it has no impact on them and their rights. Just a quick question. So please list the restrictions an investor should ask for in order to protect their position. Sure, Andrew. So not to get too far ahead, but very quickly, an investor will often want preferred stock. Preferred stock carries with it certain economic preferences. It'll be at the top of the stack if you ever have an M&A transaction, meaning that it's kind of the last dollar in, first dollar in concept. In certain situations, an investor might ask for dividends, an annual dividend of anywhere from 4 to 10%. I'll tell you that for an early stage company, that's pretty unusual. In addition, investors will look for protective provisions in which they have the ability to say yay or nay on any future material company actions, like if you want to raise another round or if you would like to sell the company, the investor will typically have a say. In addition, investors will almost always have a seat on the board, lead investors, that is. And so that at the highest of levels, Andrew, is what the investors typically look for. And we'll certainly circle back to this at the end of the presentation. So I'll just kind of run through this pretty quickly, but who is a founder and who gets what? Again, this is just making sure that you've thought through who really had the idea, who can execute the idea, who's going to stick around, who is replaceable, how much ownership should each founder get? We've just touched upon the vesting concept and potential forfeiture of stock. And so these are just things that you want to think about if you are standing up a company with a friend or a colleague or a business relation. Equity compensation. quickly, so there are, generally speaking, if you're a corporation, two forms of equity compensation. It's either a stock option, that's an option to purchase common stock, or an equity grant, which is essentially a restricted stock agreement where the company is directly issuing common stock to the employee. The restricted stock is typically subject to vesting provisions. In the construct of a limited liability company, LLCs have the benefit of potentially issuing out profits interests, which are equity rights that can be granted to service providers. Profits interests are a function of the Internal Revenue Service, something that's been created by the Internal Revenue Code. And long story short is the best way to think about profits interest is that it gives the profits interest recipient upside. If the company has a great sale transaction in the future, the profits interest recipient will share in the proceeds payable on that transaction. Phantom plans, just flagging for you if you've ever heard that term, that can be considered phantom plans, phantom equity. That is a fancy way of dressing up a bonus plan. It's not true equity. It gives the phantom equity recipient the right to receive a portion of proceeds in a sale event. That is a complicated structure. It's very similar to if you've heard of RSUs. It gets a little bit tricky and wonky very quickly. But I think generally speaking, if you're an early stage company and you're a corporation, you should be thinking about restricted stock or stock options. If you're an LLC, you should be thinking about profits interest. Any questions on founder stock, around equity compensation? We'll get into some concerns and points about potential pitfalls of equity compensation in a minute. Okay, so let's now chat about equity compensation minefields. So this is in the case of you've already formed your company. If you're a sole founder, have received your equity, or if you're co-founders, you both have received your equity out, and now you want to hire the third employee or third service provider of the company. Now, as a startup, generally speaking, you don't have a lot of cash or capital, right? And so the best way to attract talent is to offer them up equity compensation. Now, that is good. That is why when we incorporate our startups, we provide them with equity incentive plan that allows them to issue out options, right off the bat. What often happens is that the approach to equity compensation can be handled or addressed loosely. And so, you can have a conversation with your third employee and say, look, we'd love for you to come on. We promise that we will give you 5%. But the company never actually papers that. Or they tell the third employee that you'll never be diluted. And so that's a really, really common thing that often we come across. Finally, I have no issue or problem with some early stage startup companies using some of the online platforms like LegalZoom. If you're able to, if you think that's the best path for you, that's totally fine. Just know that. Sorry, guys. Oh, God. I don't know why that just happened. Very fast. So sorry.
I'm sure.
Yeah, that's what I'm doing.
It wasn't gonna go the other way.
I know it didn't.
Only 4. It's like startups. Never.
Jeez, so sorry, everyone. Get this. What I'll do is I'll just, and these slides will be circulated. Let's just continue to work through this. This is fine. Okay, so very quickly, again, I have no issue with my early stage clients. They come on board with our firm using, platforms like LegalZoom. That's totally okay. I would just, flag for them that the minute that their cap table starts to get complicated or they start to bring on employees, that's the best time to be engaging a firm like Polsinelli, in large part because of this issue. Totally understood that when you are standing up a company, your focus is going to be on your business and your operations, and you're not going to be too worried about your documentation or your paperwork. But I can tell you that if you don't actually paper the equity compensation that you promised to some of your early employees, down the road, if the company is successful, and you don't have an actual paper document that tells employee number 3 how much they own, they're going to claim a whole lot more, right? And so it starts to get very tricky very quickly if you don't have a proper and fulsome equity agreement. And so that's just a kind of a warning, if you will. And so, yeah, equity compensation best practices. Don't just promise percentages. Don't just document percentages. Always speak in terms of the number of shares and what they represent. When you issue options or restricted stock to someone, it's going to be an option or restricted common stock agreement. Number 2, this is the big one. And this is just a blanket rule. Every situation can be a little bit different, but generally speaking, we highly advise to avoid giving anti-dilution protection to founders or employees. What that means is that a founder or employee should expect to be diluted by future equity rounds. They should not just expect that their 10%, 20% will always be evergreen. The way that investments work and the way that additional issuances of equity work means that all existing owners are diluted down by investments that come in or equity that's granted out. Now, there are certainly ways to top off your employees or founders as time goes on to allow them to recoup some of their percentages. But, generally speaking, we do not like to give anti-dilution rights to founders or employees. Next up, keeping accurate cap tables and stock ledgers. That really does matter. You want to really record essentially every single share of stock that you issue out, not only because it's just good corporate hygiene, but also because if you do want to attract capital in the future, your potential investors will diligence that. And so they're going to essentially want to be able to do a cap table tie-out where they understand fully every line item on the cap table or stock ledger and its corresponding stock issuance document. That dovetails into getting the correct approvals for grants. And so in the context of a C corporation, you can't just go ahead and say, okay, Joe Schmo, I'm going to issue you 20 shares and that's that. You have to have a formal board consent that approves the stock grant or the option grant. And again, that is something that potential future investors will diligence. Are there any questions about equity compensation, founder issues? We're going to dovetail right after this slide into protecting intellectual property. But before we do, does anyone have any? I see some chats. Sorry, I'm laughing. Andrew, I'll answer your question in 1 second. But any questions in the room about equity? Nope. Great. So Andrew asks, what about limits on dilution? And he says, otherwise, I will dilute you to the strength of Bud Light, which is a good question. So generally speaking, there are no limits on dilution on founders or employees because every single holder of shares of common stock is diluted at the same rate by new money that comes in or by new shares that are issued out. And so generally speaking, this is partially why this is why we have convertible notes where you're kicking the can on on valuation. And it's why when you raise money, you want to be doing it as high a valuation as possible to limit the dilutive impact of a round. Everyone is diluted at the same rate because when you have, let's say, 100 shares of common stock that you've issued to founders and employees, when hypothetically you were to issue 25 shares of preferred stock to an investor, all 100 shares equally bear the dilutive impact of the 25 shares of preferred stock. And so that everyone essentially shares pro rata the dilutive impact.
But a couple of the limits are your amount of authorized shares to start with, right? So I mean, there's a couple of, I mean, you still ultimately, if you have full control of the corporation, board and shareholder majority, then you can oppose everyone, that's for sure. Now you're gonna run into Delaware law of whether that is appropriate or not, right?
Yeah,
that's backstop.
Yeah,
Authorized shares.
got it. Yeah, I think so, Andrew. I think that's probably what you're driving at. That's a really good point, Hubert. I think if you are, say, the controlling stockholder or board member, yes, in theory, you could kind of, issue a bunch more stock to yourself and dilute down your other common stockholders. That would, from my perspective, absent extreme circumstances, be a breach of your fiduciary duties to all of your stockholders. When you are a controlling founder, you have duties to all of the persons on the cap table. Can you go into depth on why not to have anti-dilution for the founder? This is a question asked by Mina. The long and short of it is that your investors won't accept it. It's not going to be something that an investor is willing to abide. The way that venture capital is set up, the way that institutional investments are set up, investors, when they put their money in, are taking a chunk of your business, right? And a chunk of your ownership. And so if you have an anti-dilution provision for a founder, where does that ownership percentage come from? So that is primarily why investors just will not accept it. And Hubert, I don't know if you have any additional thoughts on that, but it's just generally not something that an investor is going to accept.
It's a major red flag.
Yeah.
Would never invest in that.
Right. Yep. Mina asks, what are other strategies to protect yourself as a founder? That's a very fair and valid question. I think that number one, running a clean business with good corporate hygiene is key. Maintaining a majority position, above majority position before you take on institutional or venture capital. Not taking on too much in terms of convertible notes. So, if we think about how you raise money, there's typically for a startup the ability to raise what I'll call pre-seed money on a convertible note. The convertible note would convert into equity in the future. There's a benefit with convertible notes because you get to, generally speaking, kind of kick the can on doing a full-born priced equity round, which can be expensive. In addition, you can kick the can somewhat on your pre-money valuation. But what often happens is if you're raising millions of dollars on a convertible note and it converts into equity, you can have unforeseen consequences when it comes to dilution. And so I think, make yourself invaluable to the company. Generally speaking, when an investor is investing, they're not just investing in the company's operations, they're investing in the founders, right? And so they want you to be there. And in fact, more often than not, when you receive an investment from an institutional investor or venture capital fund, if your common stock is fully vested, they're going to want to put it subject to revesting to ensure that you're sticking around. And so, Mina, I don't know if I did a great job answering your question, but it's a very thoughtful one to make sure that you are protecting yourself. Next up, protecting your intellectual property as a startup. Generally speaking, this is where outside of kind of, I see more litigation on intellectual property issues for early stage companies, or I see this being the red flag for investors. So as an early stage company, you want all of your service providers and founders signing up to NDAs and assignment of invention agreements to ensure that your startup entity has ownership and control of the intellectual property that is being created or assigned by the founders and service providers to the entity.
You said assignment of what?
Assignment of IP. So let's say, and this is in the case of you have two founders, they have some really good ideas about a business model, or maybe they've got some sort of technology they want to contribute to the company. We would just have a very basic assignment of intellectual property agreement that would allow that IP to go into the new code and be owned and controlled by it.
Would this include like a logo?
Yes. Yep. Yeah. And so if let's say that a founder has registered the logo or the trademark with the United States Patent and Trademark Office, you would want to assign that logo or trademark to the company if you're going to be using that logo and trademark in the company's operations, and we'll use it to, raise money from investors.
Could it be a percentage other than 50-50? This person brings 80% of the IP and this person brings 20 or something like that?
Yes, absolutely. Yep. Yeah, it's really the percentages that are issued to co-founders. It's very fact specific, right? And so there's obviously always kind of a drive towards 50-50, but I think it's, in my experience, you want to be very thoughtful around what each co-founder will receive. And it does not have to be 50-50. Yep. And so, just very quickly at a high level, you want to be aggressive in protecting your IP. You want to, explore whether or not your technology is patentable. You want to file trademarks on your company names. If you have logos or brand marks, you want to file trademarks on those as well, to prohibit anyone else from using those marks. If you are, developing code or another type of tech stack, you can consider going through potential copyright protection. And so there are a number of ways to protect your IP. But if that is your secret sauce and that's something that you need, that your business is going to be built upon, you just want to do what you can to protect it as much as possible. This dovetails into agreements with current and former employers. So this is an issue for, say, two founders are currently working with a third-party established business, Fortune 100, Fortune 500 company, but they want to step out on their own and do something new. Before doing that, those founders absolutely need to review their current employment agreements and ensure that those employment agreements don't have any sort of restrictive covenant tail that would prevent them from either competing with their current employer or soliciting any of the current employer's clients or employees. In addition, you want to make sure that any independent contractor or consultant you bring on at the very beginning, you want to make sure that they are also aware of their potential restrictive covenants. The worst thing that can happen for a contractor to come on board and be bound by a existing agreement that prevents them from providing services to you as a startup. In addition, if you are, this happens quite a bit, and it's totally understandable, if you are, slowing down with your current employer and you're looking to, start up this new company, and if you could even be deemed to potentially compete in the same sphere or vertical, never be taking your employer's customers list, marketing materials, employee data. If you're trying to stand something up on your own, just be very careful about using your current employer's computers, phones, etc. I think that hopefully is pretty obvious, but it can create major issues. I've seen a lot of cease and desist letters be sent to my founder clients. And again, very quickly, other organizational considerations. Again, we've touched upon maintaining a liability shield. When you start up a startup, have a separate bank account. Make sure that you are signing contracts appropriately. try to do your best to maintain corporate formalities, have meetings of the directors. In addition, are you a regulated business? Do you need additional qualifications, licenses, permits? That is something that attorneys or other advisors can help you on. Make sure you've got your arms around sales, franchises, and other taxes. If you're, say, a CPG company, are you selling to multiple states? Are you making sure that you have a grasp of what your sales tax liabilities could be? Intellectual property, we just touched upon that. QSBS, this is the Qualified Small Business Stock, Section 1202. This is a wonderful tax benefit that is only granted to C corporations in the United States, and it allows stock that qualifies as small business stock under Section 1202 to avoid up to $10 million in tax exposure in the event of a sale of the C corporation. So that means that if you're a founder or if you're an investor that has received qualified small business stock from a C corporation, you have the opportunity to avoid up to $10 million in federal tax. Now, there are a handful of other boxes to check to ensure that the stock qualifies as QSBS, but this is a very, very nice benefit that the Internal Revenue Code offers to C corporations.
It can be a really big deal, and then you might end up investing with convertible note and that will not qualify.
Right.
And so this really rewards early seed equity investors. I think you have to hold for 3 years, 5 years.
It's a 5-year holding period, and there are some other rules around redemption and the like, but it's a really nice benefit.
And it can work.
It can work.
For us.
Yeah. And I know that we are out of time, and so I don't want to keep anyone. I had 1 or 2 more slides on just raising money. If everyone will just bear with me for 1 minute. So typically speaking, if you're a very early stage company and you are looking to raise money, you have a number of buckets. You can explore friends and family, angel investors and seed funds, accelerator funds, venture capital funds, corporate venture, or what I call institutional strategics, or strategic investors. And so I would say that, prior to your Series A round, your best bet is going to be friends and family, angel investors, accelerator funds, venture capital funds, especially after 2021, 2022, they want to see revenues before they invest. High growth potential companies. This is just a quick slide on what what venture capital funds like to look for when they invest. And finally, I'm just going to touch upon pre-seed rounds, convertible instruments. And so when you start up, you've incorporated your company and you're looking for outside capital, typically the best and quickest way to bring outside money in the door is via a pre-seed convertible instrument. It's faster than a priced equity round. And again, you do not have to establish a pre-money valuation. So it's essentially, an angel investor or an accelerator or friends and family. They'll invest today for a convertible note or a SAFE, which is a simple agreement for future equity. And in the future, they will receive equity in connection with your first priced equity round. And so I think it's important to think through that if you do raise on a convertible note or SAFE, you will be expected by your investors to raise capital in the future. And that's a key point. We have some companies that have convertible notes that have been outstanding for 3, 4, 5 years and are still trying to kind of not raise capital. But just know that if you raise the pre-seed round, you should expect to go for a Series A priced equity round. And there are many other attributes of a convertible note and a SAFE, and I'm glad to answer any questions that anyone has about those instruments. But I know that we are up against our 1 o'clock end time, and I just do not want to keep anyone. And so that is it. There's a lot in these slides. I know that Lindsay will make these available to everyone, I'm sure. And my information is available on these to the extent that you have any questions. I'm also going to be sticking around for the next half an hour or so if I can answer any specific items that anyone would like to discuss. But I thank you all very much for being here today.
Thank you. Thanks, Chris. And obviously, we could also take a few online if somebody wants to ask the last couple of questions, but then we'll flip the switch on Zoom probably. So
Yeah, we'll give Zoom just another 2 or 3 minutes for any questions. Sign off.
I think on the convertible notes, something that is often a concern is that they have a 18-month or 2-year time span, which gives worries in startup entrepreneurs because the loan is due unless it converts. And more often than not these days, it doesn't, because the startup decides to create another convertible note, and there is no price to equity round, which could cause the conversion. So what generally happens is that you roll into a new note, or the note will just be extended. And so the one feature I like about convertible notes as opposed to safes is they compensate different people coming in at different times and different risk by the small amount of interest that's being paid. And usually that gets rolled into the next convertible note as well. So the safe don't do that. And so unless you can raise the whole slog in 1 month, why would you invest now and just wait until the very end of the safe round? So here's a kind of a nice incentive to say, no, invest today. You'll start accruing interest. We know it's not much, but the guy that invests, or the gal that invests 3 months down, they will not get these 2 extra percent as a kicker, basically.
Yeah.
But that's a very common concern. What do you do now that loans due?
Exactly.
And, but the investor has to make a decision. Like, you and I call the loan and kill the company. That makes not a whole lot of sense. So,
and I totally agree with you.
You have to have. You're buying yourself that conversation in 18 months.
Yeah. Yep. And so
Equity, no such
on the company side, we like to see safes for that very reason, because it has a maturity date. The convertible note does, right? And so investor or founders, it just makes them very anxious or itchy, right? And especially if they have investors who are, say, friends or family or angel investors that might not necessarily take the same approach to convertible notes, and think that the convertible note maturity date gives the investor a cudgel over the company to try to force the company to take actions that the company does not want to take. On the flip side of that, Hubert, I totally agree with you. My investor clients, we are pretty consistently still doing convertible notes because we want to, the maturity date is important. Like if you set a 24-month maturity date, then that should be your timetable for an equity round. And in addition, the interest rate, it's not massive, but it's a nice kicker. And it shows and acknowledges that, you as an investor at this early stage, being rewarded or compensated. And then, to the extent that this might be obvious, not obvious, but simple agreement for future equity is a relatively new instrument. It came out of the Y Combinator accelerator over in Silicon Valley. It's pretty market accepted. And again, the key difference between a safe and a convertible note, it's really two. It's the safe does not have a maturity date and does not have an interest rate. But the expectation should be that both instruments will be converting into preferred equity in the future. The safe, yep. So both convertible note and safes can have valuation caps or discount rates or a combination of the two.